This is a lecture for my administrative law class and also my legislation and regulation class about Humphreys Executor, an important old case that from the US Supreme Court. Just give me a moment. So here we're going to talk about Humphreys Executor versus United States. And also, this is where we started our notion of independent agencies, and which is part of what we cover in this chapter when we talk about appointment and removal powers. We talk about this thing known as independent agencies, which, as you'll see, is a little hard to define. So here's the background on this case. The backstory is actually kind of interesting, even apart from the legal conclusions of the Supreme Court. So Calvin Coolidge appointed William Humphrey as a member of the Federal Trade Commission in 1925, and then gave him another 6-year term in 1931. Humphrey had been a junior congressman and was very outspoken. He was one of these people who was always grandstanding for the Republican Party at the time and criticizing Democratic officials and so forth. So he was very outspoken, kind of a fiery personality and an up-and-coming person in the party. And so he got taken from Congress and put in charge of the Federal Trade Commission by Coolidge. Now then Roosevelt wins in 1933 and with a mandate to implement the New Deal. So here we are in the New Deal legislation, and Humphrey is Roosevelt's kind of nemesis, or one of his a very long-standing personal enemy. So Humphrey is very outspoken, critical of Roosevelt in the press all the time, and is refusing to implement some of Roosevelt's New Deal policies. And remember, we're talking about the Federal Trade Commission, which is sort of at the heart of a lot of the economic reforms, or the reforms of the American economy, to try to pull us out of the Great Depression. And so in Roosevelt's view, he did not support his New Deal policies vigorously enough, and they started fighting. You should also know that Humphrey apparently ran the FTC like a little tyrant, and he was a very bossy, domineering person by the accounts of the time, and who sort of treated the FTC like his personal fiefdom, even though it was supposed to be a commission of sort of equals. So he was an outspoken critic of FDR and became his nemesis, and he ran the Federal Trade Commission like a tyrant. So Roosevelt asked for his resignation twice, nicely, and Humphrey said, no, I'm not going to resign. And so Roosevelt then fired Humphrey, and with this statement, effective as of this date, you are hereby removed from the office of Commissioner of the Federal Trade Commission. So it's a very succinct letter, and he didn't state any reasons for it, or cause, or mention anything that Humphrey had done wrong, even though he probably could have. He probably could have said that, look, it's your duty to implement policies of the administration. You're thwarting our objectives, and we have a depression going on, and so you need to go. And given some reasons, but he didn't. And this was a bit of a power play and an ego issue for Roosevelt. So Humphrey didn't like that, and he continued to come to work at the FTC even after he was formally fired. He basically said, you can't fire me, I have a term of office, and you have to state cause under the statute. And then Humphrey dies in his bed. So the autopsy, I went and looked it up, says natural causes. Humphrey was 57 years old and not known to be in bad health, but as soon as the case gets going, about 3 weeks into it, he is found dead in his bed and supposedly peacefully died in his sleep. So before the Supreme Court could rule on whether his dismissal by the president was valid, he died. And that's why this is called Humphreys Executor, because the executor of his state continued the claim in order to get the back wages that he was owed to put into the estate to distribute to the heirs. Now, let's talk about the statute. The Federal Trade Commission Act says that the president can remove commission members only for inefficiency, neglect of duty, or malfeasance in office. So this is a little different from the Myers case, which I discussed in another lecture, where we had a statute saying you had to get the Senate's approval to remove people. Instead, it lists the permissible grounds for removing a commissioner. And this was sort of a statutory innovation in the act. And FDR's removal of Humphrey was based solely on political differences rather than job performance or alleged acts of malfeasance. Now, I have to tell you that FDR's lawyers thought that Myers would control that case. Myers versus United States had basically said they thought that Congress can't put any restrictions on the president's removal powers under the Constitution. So they thought this was going to be an easy case and sort of walked into court with a chip on their shoulder. And also for FDR, this made him really upset, right? So here my enemy is harassing me even from the grave and so forth. I thought I was finally done with this guy, and now it's going to the Supreme Court. And remember, this is the tail end of the Lochner era court that was resisting and overturning a lot of FDR's New Deal policies. These are cases that you studied, maybe Lochner era cases in your constitutional law class about the takings clause or the contracts clause, where they invalidated early New Deal initiatives or the non-delegation doctrine. And before the court kind of woke up and decided that they liked the New Deal. And this was the case that triggered FDR's court packing scheme, which has suddenly become a topic of much public discussion in the fall of 2020 when I'm recording this video, the idea of court packing. And so FDR had a ongoing kind of standoff with the Supreme Court leading up to this case, but this case was personal. Humphreys had really gotten under his skin. And so when he loses this case, after his lawyers told him it was a slam dunk, he sort of blew a gasket and decided that, you know what, I'm tired of this. And this is why he drafted his proposal to have mandatory retirement for Supreme Court justices at age 70 and to expand the Supreme Court to 15 justices, which would have allowed him, between the retirements and the new appointees, the new members, to appoint a majority who would uphold his policies almost overnight. As you probably know, they dropped this, right? They didn't actually pursue it or push it through Congress, the court packing scheme. But if you remember the court packing scheme, this was the case that was the last straw and prompted or triggered Roosevelt into doing that. Why did Roosevelt back off? Because one of the first Justice Roberts on the Supreme Court realized what was about to happen and changed his mind and switched to Roosevelt's side. And so sometimes we call that the switch in time that saved nine. And because he said, okay, fine, I'll be on your side and uphold the New Deal legislation, which made court packing unnecessary. Okay, so the court in this case, let's go back to the case. That's all. The history is very interesting. The feud between Humphrey and Roosevelt is an interesting power play between two very strong larger than life personalities. But then we have our kind of mundane legal issue, and that is the statute and whether statutes are allowed to say, okay, you don't have to get Senate confirmation to remove people, but you do have to show cause for removal. You can't remove people just because you don't like them or they're from the wrong party or they're not loyal enough to you. They have to have done something wrong, and you have to therefore articulate what they did wrong. So here we have this problem of this other case, Myers, that seemed to say Congress can't impose restrictions on the president's removal of executive branch officials. And so the court distinguished that and said, look, there's a distinction between executive officers and quasi-legislative or quasi-judicial officers. So the latter may be removed only with procedures consistent with statutory conditions enacted by Congress. And the former serve at the pleasure of the president. They're basically at-will employees in the executive branch, and they can be removed at his discretion. And the court ruled that the Federal Trade Commission, because they were engaging in rulemaking They were a quasi-legislative body because of other powers it had. So the president could not fire an FTC member solely for political reasons, and therefore Humphreys firing was in fact improper. So again, this case triggered the court's FDR's court packing scheme, and also the decision furnished the constitutional basis for independent agencies. Now, I want to explain one more thing about Humphreys Executor very quickly. So first of all, the court adopts an analysis, a rubric for analysis or a methodology we would call functional. So they're going to look at what does the agency do? This is different from what we might call a structural separation of powers argument, or a formalist one where we're just looking at what does the Constitution actually say and call things. So they look at the function of the agency. What types of things does it do, and how much do those look like executive versus legislative versus judicial? And if it's really purely executive, like the post office case was in Myers, then the president, all these appointees serve as at-will employees of the president functionally. If they're doing things that overlap with functions of the other branches, then Congress can kind of put some conditions on the president's removal. They can't keep the president from removing someone necessarily, but they can impose some conditions on it. And this was a new idea and led into our modern issue of independent agencies. The other thing to keep in mind is that you reach the end of the decision, and one of the last things the court addresses in Humphreys Executor is, do we have a bright line rule? Like, how do we know if future cases are going to be, we're going to say this is more executive like Myers, or more quasi-judicial and legislative like Humphreys Executor? And the court expressly refuses to answer that question and says we're going to take it on a case-by-case basis, which in a sense gives the Supreme Court more power to not answer the question, so that every case is going to have to come before them and they're going to get to haggle over it among the justices. So let's go back to the slides for just a moment. We have a closing point to make about independent agencies. And the bottom line is, we talk about these things, we know they exist. The court has called certain agencies independent. Congress has called certain agencies independent, but there's not a bright line rule or clear definition of what's an independent agency and what isn't. And so you need to know that. Instead, we have some factors that may or may not make something an independent agency. So most of them are going to have a for-cause removal provision in their enabling statute, like Humphreys Executor. That's a good indication that maybe it was supposed to be a little more independent from the president than purely executive branch entities. Now, please, from your kind of civics class standpoint, these look and act a lot like executive branch agencies, but they're sort of floating out there somewhere as having a little more independence from the president, or a little less presidential control, only in his ability to remove commissioners. But also, a lot of these have multi-member boards or commissions instead of a director or secretary. And most commonly it's 5 and sometimes 7. And they usually have staggered terms of either 3 years or 5 years. So what this means is, whereas most agencies like the EPA, the president can come in and just appoint a new director or administrator of the Environmental Protection Agency that agrees with the president's policy agenda and is planning to implement it. And with a board or commission, anybody the president appoints could, in theory, get outvoted by the rest of the board or commission. So it's going to be decided, the big policy decisions by vote, and that means it's going to dilute the power of any individual one. And they usually have staggered terms, which means the president is, in theory, when they're originally set up, going to get to replace one a year during his term, but it means he's going to inherit most of these boards or commissions. Like, think of the National Labor Relations Board, or the Federal Communications Commission, or the Federal Trade Commission, or the Federal Reserve Board. So these are very important federal government agencies, and the president inherits people that were appointed by his or her predecessors, mostly, and then has to fill the vacancies one at a time as they come open. Also, some of these statutes, but not all, have a bipartisan requirement, which means that if it's 5, 3 have to be from one party, 2 from the other. If it's 7, it's 4 and 3. And so, which means you could force a president to appoint someone from the opposing political party. And some presidents don't like to do that and will stall on these appointments and try to leave things vacant. Now, if you're for some of you, we've hit a new low in terms of interest level, or this is very boring, but this issue of independent agencies is in the background of some of our remaining cases in this unit, where the Supreme Court justices sometimes aren't sure whether something is an independent agency or not if it has some of these features in its enabling statute, but not all of them. And similarly, we have some questions about what do we do that are going to come up about vacancies with filling these, the vacancies on these boards and commissions. It's one thing if you have a normal executive branch agency where typically if the top person leaves, there's some sort of acting director appointed who just steps in. Often the number 2 person will just take over and be an acting director until a new head is appointed. Boards and commissions are much more complicated than that. Okay, that concludes our lecture about Humphreys Executor and our little intro to independent agencies.